everyone, welcome back to Legalese Translator. My name is Heather Hui-Litwin, and in this video again with me is Heather Douglas. Hi, Heather.
Hi.
So in this video, I just want to ask Heather to explain to us how does a judge go about considering how much money to award in costs? So Heather, could you give us an explanation?
Yeah, so the judge will look at the rules of civil procedure, Rule 57.01, and they'll have the discretion in considering the factors outlined in the rules on how much they want to award and to what party they want to award costs to. The costs are completely in the discretion of the judge, and it's incidental to a proceeding. So the court may ultimately decide no costs are going to be awarded. So it's not even a guarantee that you're going to get it. But looking at the rules and looking at the case law on costs and on Rule 57, there are some common themes that have developed in the case law. So these common themes are that the costs that are awarded normally follow the event. So that means that costs are usually at a partial indemnity rate and that they are ordered to be paid by the unsuccessful party to the successful party. Another common theme is that they're normally around the partial indemnity rate, so it's normally around 60%, so somewhere between 50 to 75. Most lawyers will calculate it around 60% or 66% for partial indemnity scale. But Rule 1.03 provides a definition, and we go through that in another video in more detail. Another theme is that the costs can be awarded against a successful party, but that's in exceptional cases that you will see a court say, even though you've won, we're not going to give you costs, and we're going to order you, the winning party, to pay the losing party for their legal expenses in pursuing this proceeding or pursuing that step in the lawsuit.
Mm-hmm.
Another one is that costs are usually awarded by what a judge will think is fair and reasonable in the case. So they're going to look at a bunch of different factors to see what is fair in this case. They're going to look at how complex the motion or how complex the lawsuit was. They're going to look at what steps were taken by the parties if they did anything that was improper. They're going to look at whether you could have been more agreeable at certain points and admitted certain facts, but you refuse to do so. They're also going to look at the costs that were incurred by both the parties to kind of see what's reasonable in this case. So if both of them are around a similar amount, they're going to know they're in a good ballpark. But if one is really high and one is much lower, and there's no strong explanation for why it's so high, then they're probably unlikely to think that that high amount is reasonable or fair. And the last theme that I'm going to talk about is the ability to pay costs. So there is divided case law on whether a party's ability to pay should be taken into account. So sometimes the courts will look at whether a party has deep pockets, or more likely they'll look at, the party has no money, and they might consider that in how much they're going to award against or for a successful party.
Okay, so let's say that I was a self-rep and I represent myself at a trial, and I didn't know Rule 57's Rule 57 factors. When the judge goes about deciding costs, would they go on their own initiative to apply Rule 57, even if I didn't bring it up?
Right. So you're asking, does a litigant have to ask for the relief? Do they have to ask for costs to get it?
Yes.
Typically, the court will not award you something if you don't ask for it.
Right.
Ultimately, it's in the discretion of the court to grant an order for something that hasn't been requested, but it's rarely done, especially because the court wants to ensure that the other side has notice. So if you never gave notice that you want to have costs for that motion or that lawsuit, then the court might be hesitant to award it because the other side, while they were planning and working on the case, didn't have notice that that was something at issue. So it's really important that if you want costs, that you explicitly state it, because if you don't, the court may be unlikely to award it to you. But ultimately, it's in the discretion of the judge to make that kind of decision. But I wouldn't rely on the good graces of the court because they really want everyone to have notice of what's at issue.
That is a great point. So basically, if someone is thinking of starting a claim and they wanted to draft their own statement of claim, that they have to make sure that they have a claim for costs in that document. And same for motion. If you're a self-represented person and you want to bring a motion, you have to be sure that you mention that you're also seeking costs.
Exactly. Make sure you mention that. Yes.
Wow. Those are really fantastic recommendations. Well, thank you so much once again, Heather, for your wisdom. Thank you everyone for watching. If you are new to this channel, don't forget to hit the subscribe button and hit the bell so that you'll be notified of our upcoming videos. And we hope to see you at our next video. Thanks so much. Bye.
Bye.